do you know, I know Gordon's on here, probably a little more tech savvy than myself. Do you know how, if we're able to expand past the 100?
Is this city-owned Zoom
No,
session?
it's mine. I think that's
You
the
would
one.
need a webinar license. A webinar license can handle up to 500, but if you don't have a webinar, then you're maxed out at 100.
Okay, that's, I'm sure, my thing then.
Okay. Thank you, Rodney.
Can we transfer it over to our webinar, Jen, or is that impossible?
That's what I was going to suggest, if it's even possible.
You need to get invitations out to everybody.
So true.
Yeah, that would be probably a little bit of a lift.
How many people RSVP'd or are required, Jen, do you think?
A couple people jumped off, so it's interesting.
Huh. Yeah, we have, it's for managers and supervisors and above. I know we've had a few that are non-supervisors sprinkled in here, which is great, but
Just curious to know if it's like 50 people or like 2 that we're missing.
it's hard to say. I haven't finished the attendance.
Okay, why don't we give it 5 minutes, and if it's like, you know, more than, I don't know what you all think is a good cutoff, but 20 people or something, then we spend a little more time trying to figure out if we can do the webinar, otherwise forget it.
Yeah, good question.
Yeah, this is Roger. The link is a little confusing because there was a Google meeting. So it said join with Google Meet. I clicked on that first and just sat there waiting, and it timed out. Then I went back and used the Zoom link. So I'm wondering if people are having trouble linking in.
So far, I haven't gotten any emails from employees acknowledging difficulties, but I'll keep an eye out.
You say the word when you want me to go, or if you want to do an alternative mode. Whatever works best for you.
Give me 2 more minutes. Jack, go ahead and go. I would say we have less than 10 people that haven't been able to log on.
Okay, good. And then please encourage others to watch the video. As I said, there's a lot to talk about. I certainly regret that we've reached our max in this regard, but please pass along the video I'm making to everyone. And I noticed that people are sort of jumping in and jumping out as well. So hopefully they'll be able to see, as I see when room comes in, I'm just going to include people along. Most importantly, thank you for joining us for the program. It always seems like it's the highlight of my year for us to get a chance to talk. For those of you who've never seen me do this before, it is Chuck Basalia. I think I consider myself to be a friend of the city in this regard, and I'm going to make sure that I do justice to the topic today. This has been an amazing year. In fact, I have to tell you, as I thought about putting the class material together, I look back months ago to what I thought the year was looking like in April of 2020, and that was a veritable wasteland. I have no idea why there's an image across the front of my I must have drawn something, which is strange, but it was a veritable wasteland seemingly months ago. And then things started to improve considerably. You might know Zoom has been our constraint for many of us over the course of the year. I'd never even heard of Zoom, I'll be honest with you, before March of 2020. And now I seemingly use it every day. And I am one of those people who finds myself from time to time in my pajamas on Zoom calls, talking about what's happening in the workplace. And so it only gets better. Then I think people started to come out of the wilderness and figure out that in order to make our way through this pandemic, we're going to have to work together. I include myself among them. And that's when I started to put together this program. What do we need to know as far as being employers, being managers, being people who are responsible for others in a time of unusual circumstance? And that gets me to what's going to happen next year. And I am one of those people who is an eternal optimist. And I think the world is going to get substantially better, especially with these promising results for a vaccine and people's understanding that once we get through the dark time, it's going to be a lot better for people in terms of work and work expectations. So if you wouldn't mind sitting back, let's talk about a few rules of engagement. How do these programs work best? You remember when we do them live, they're fun because you can raise your hand and throw out a question. I encourage you to still do that. You're allowed to unmute as we go through the program, ask a question. But Jen alluded to this earlier in the introduction when she was asking about your attendance. I have now found that this format is tremendously good because if you're familiar with the chat function, and that's what Jen alluded to earlier, the chat function, it's in the toolbox. As you go through the toolbar, off and over to the right, there is an icon called chat. Please pull up chat. Feel free to ask questions. I monitor chat as we go. And chat is a great way for you to potentially ask questions without really slowing down in any way the class. And what I really like about chat is I monitor chat as the host. On this function, not that I think it's necessarily a good or a bad thing, but what I like about it is you're allowed to send me a private chat. That is a great way if you have a question you'd like to ask offline. I encourage people to send me a private chat, or a few of you have already done that. And I want people to feel comfortable asking me questions if they don't want their identity to be known. I never divulge the name of a person who sends me a private chat message. I just consider that to be a matter of respect for the audience. So I encourage you. That goes to the next issue. I'm going to go through the program as quickly as I can. There's a lot to talk about this year, but the only thing that will peel me away from this computer screen is a liquor delivery. I'm not expecting a liquor delivery, but we have had to adapt in these times. And so I am going to run through the program in its full measure without taking a break. That's good for you because we move relatively quickly, but would you feel comfortable taking your own break? I think you're used to this format now. Everyone's familiar with this methodology. So if you have to take a phone call, if you have to potentially look over a kid who's being taught at home shoulder, I encourage people to do that during these programs. And that's just the way we all have to adapt to these times. We'll talk a little bit about that. Last thing to mention, I think Jen already knows this. The rest of you may not know that, but I had a baby during COVID, and it's this book. I encourage you, if you are in any way interested in employment law topics, how good people make tragic errors, you should consider getting this book. That's a shameless plug for the work I did during COVID, available on Amazon.com under my name. So a lot of what we're going to talk about is embedded in this book, interestingly enough. But I wanted you to be able to, thank you. I got the private chats already coming in. A lot of you know I've been working on this for a long time, and I have a lot of friends that are on the program here. In fact, it's good to see so many of your names, so you'll indulge me as we go through this. So let's talk about work. Let's talk about what to expect, and let's talk about us. So I threw out a lot of issues in no particular order. A lot of you already know. This has been, oh, thank you for the congratulations. I'll type in the name of the book, but just so you know it, it's Can I Bring My Pet Monkey to Work? So that's important. If you Google pet monkey to work, you'll find this on Amazon quickly. Let's talk about work. So interestingly, it's been an incredible year. I have to also say as an outset, you have to put this year in the context of incredible division, of incredible social strife, of incredible desire of people to be heard. That may be many of you, and we're going to talk about that because part of this program is not only do people want to be heard, not only do people have a lot to say about the current condition of our society, but a lot of what people are saying has affected the law of the workplace. And it's going to be upon managers to have some understanding of this. So when we have employees who have strong voices, it's our obligation to potentially manage that successfully in the workplace. I wanted to give you that preface because I wanted to talk about this first provision of Colorado law. Something I'd like you to think about having an understanding of is Colorado's new Crown Act. This is an acronym, and the Crown Act is creating a respectful and open workplace for natural hair. I know this sounds like I'm starting off kind of way down in the weeds, but interestingly enough, this is a measure that is sweeping the country rapidly. You might recall some of the circumstances that have brought this law about, including Colorado, and that's where organizations famously, a wrestler, high school wrestler in New Jersey 2 years ago, was stopped before proceeding to a wrestling match and was forced to cut his braids, and it caused nationwide attention. Well, now courts and legislatures are addressing the issue of race in particular with expanding protections under our civil rights laws. So now Colorado joins a few states, and this is important for you to know, because not only is the city an employer, but the city is also a place that invites members of the public to it. And it's important that you understand this newfound protection. So now schools, workplaces, that's us, and places of public accommodation where the public can come to have their needs met, which is also the city, protects people on the premises who desire to wear their hair in ways that are commonly associated with racially identifiable styles. That includes such things as, oh, awesome. I love the comments coming on chat. Please keep them coming. And so interestingly enough is dreadlocks, braids, twists, Bantu knots, afros, head wraps. And yes, I am recording. I want to make sure that people know that. So it's important that we capture this for anyone who watches it after the fact. But it's very important that, and I try to give a learning point on every one of these slides, it's very important that people understand this. You may have an employee or you may have a member of the public who desires to wear their hair in a traditional manner that is identified with their race. I also want to be clear, when we talk, I hold you to a high standard. What's important for your understanding also is that it's not just about race. There are many groups that have identifiable hairstyles, and the other one that comes to mind commonly is Orthodox Jewish persons who might wear their hair in religiously and racially identifiable hairstyles. So managers, know this. In a world in which people are asserting their rights and people want to be heard, this is something you are going to contend with, especially as we get back together, when we're in community again and not working remotely. You are going to have people, including employees, who desire to wear their hair in traditional styles, and that is now protected under Colorado law. Do have to mention one thing about this though, because you all do difficult jobs. Nothing about this particular law takes away any of the responsibility to maintain the safety of the workplace. We were talking about this earlier with in the organization. We still have a responsibility to maintain safety. So please note that hairstyles are protected, but hairstyles that potentially interfere with safety responsibilities are still going to have to be addressed by a manager in conjunction with human resources. Hopefully that makes sense. So please don't lose sight of that. We still have to protect everybody who works at the city. Important you know that. If you have questions, start with chat and then we can proceed and it makes it go quickly. But I want you to see this one first because we're going to talk about issues of race a number of times during the course of this relatively quick program. All right, let's keep on going. Be prepared. I love the fact, and by the way, on the HR side, Jen, HR representatives, I do expect people to also ask questions that might be inclusive of human resources. So I appreciate you monitoring chat as well for everyone. So thank you. Let's keep on going. Supreme Court. Most of you have probably heard about this case, and this case is, I love it. Thanks. As far as people joining together to watch, to allow others to include. Thank you for problem solving this issue. So next big topic. So we talked a little bit about Colorado. We talked about natural hair and appearance. Now I'm going to take it to the federal level. Excuse me for bouncing around a little bit, but I decided to take things that I thought would keep you relatively entertained, but are also important at the outset before we get way down in the weeds with some new provisions of Colorado law. Monumental decision was issued in June of this year. Employers are still trying to sort it out, and I'm going to talk about this with you. So Colorado, and a lot of you already know this from our previous times together, Colorado has long protected employees, that includes applicants for employment, from any discrimination based on their sexual orientation and or gender identity. What happened this year and what is going to make for more work for employers, including supervisors, is the federal government, the US Supreme Court, which makes federal law, well, I should say endorses federal law. They found in a case, a combination of cases now called Bostock, that you are protected not only under Colorado law, obviously, but under Title VII of the Civil Rights Act of 1964, you're also protected under federal law, our federal anti-discrimination law, from discrimination on the basis of your sexual orientation and gender identity. Why is that a big deal for us? We already have this protection in Colorado. Well, certainly it's going to invite more attention to this issue. And now it's going to invite more federal oversight of this particular issue and potentially more claims of people being mistreated. You are very effective at managing these rules, but I want to talk a little bit about these cases and I want to talk about what you can expect, because this decision is very broad and has considerable impact on workplaces. So the first, it's a combination of three cases. You don't need to know this, but I thought you'd want to see how some of these cases manifest themselves. So Bostock is pretty interesting. He was an employee who got fired solely because on his own time, he played in a gay recreational softball league. Talk a little bit about that in Colorado, that your private life is protected. In Georgia, they don't have the same protections that we have, but the employee was fired for participating in a gay softball league. Zarda is a case that you should be familiar with. In this case, Donald Zarda was a skydiving instructor, and he was doing a tandem jump with a boyfriend and girlfriend. So Zarda was taking the girlfriend and Zarda's coworker was taking the boyfriend on a tandem jump together for their first skydiving experience. And Zarda, the employee, made a joke to the boyfriend about being gay, which the boyfriend complained about to the employer and for which Zarda was fired. And the last case, which just by the way settled following the Supreme Court decision, the last case involved Amy Stevens, who for years had presented as a male when she was hired, had worked for a number of years for a funeral home in Ohio, and then one day sent a letter to her employer, a long-standing funeral home, that said, I want you to know I'm going to take a leave, and when I return from a leave, I am going to present myself and live and work full-time as a woman. Now, Amy Stevens. This was met with resistance by her employer, the funeral home, and she was fired for changing her gender identity during the course of her employment. The Supreme Court took all these cases together. They're allowed to do that. They consolidate them, and they made a ruling, which interestingly enough, by Justice Gorsuch, a very conservative Supreme Court justice, to the effect that, and you should know, because Colorado law is the same, that discrimination against a person on the basis of being gay or on the basis of their gender identity is discrimination based on sex. That now brings it firmly within federal law and therefore makes it illegal. So what's the big deal for us? We already have this protection. Why am I slowing down on this? Well, the first thing that you have to know is the law is very clear, the court was very clear about the law. And that is Title VII of the Civil Rights Act of 1964 covers every aspect of employment. So please know that. Failure to hire someone because of their sexual orientation, failure to promote someone because of their gender identity, harassment of an individual are all forms of potential unlawful discrimination. That also includes misplaced stereotypes. For example, I wrote in this book a case I had, which is now going to be very clear under these rules, where a employee was being harassed because he, quote, looked gay. Use your imagination here. It's still difficult for me to get my brain around this. But the employee was being harassed because he allegedly looked gay. Well, that's a stereotype, how you think people should look, act, or behave, which is covered by these rules. So managers, this is a big deal. When the workplace is permeated with people using misplaced stereotypes about how men and women should look, act, or behave, you are potentially raising the specter of discrimination on the basis of someone's sexual orientation or gender identity. Next issue, Supreme Court intimated that these cases are going to be easier to prove because your gender doesn't have to be the sole cause of any adverse action. This is kind of a big deal. We'll talk about it later, but I thought I'd hit it quickly with you. This is now a big deal because employees are raising claims. You don't need to know this. It's called intersectional discrimination, meaning more than one thing led to the adverse action. I happen to be male and over 40, and courts allow a combination of these claims. Supreme Court basically endorsed that and said, hey, if any part of your gender, if any part of your age was a contributing factor or a motivating factor for why you were mistreated, then there is room for that to be heard in our courts. You should know that. It's in essence easier potentially to claim discrimination. What also is important, and I wanted you to realize this because there's only two more things I need to make clear to you here, is the court ruled, and again, I hate to get so much, you know how we talk about this from a common sense perspective. That's what we want you to know about this. But the court said individuals can bring claims. is individuals are protected. It doesn't matter if women are generally treated this way or men are generally treated, or you remember we've talked about this in years past where there is an employee who treats everyone horribly. We used to call that the equal opportunity harasser defense. That's just Chuck. He's a jerk. He's not discriminating against any one person. He discriminates against everyone. Our Supreme Court may have extinguished that defense because now they say it doesn't matter if this person is a jerk to everyone. It matters if they're a jerk to this person. So please know that. This case is going to spur many, 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 many more cases. And I should also be clear, the Supreme Court failed to address two important considerations that are only going to lead to more lawsuits. The first one is Supreme Court refused to touch the issue of what about people who have religious objections to issues underlying an individual's sexual orientation or gender identity or gender for that matter. Supreme Court said that's for another day to talk about religious objections. We're going to get to that in just a second. And the other thing that they didn't talk about was where you've asked me questions in the past. Is there any clarification, Chuck, on rules surrounding locker room, restroom, changing room, recreational facilities, and a person's sexual orientation? You run recreational facilities as a city, and the Supreme Court did not go down that path as yet. So we're waiting for more information. We're waiting for some rulemaking at the federal government level to determine potentially, is there more guidance? And I would expect it in our future sessions. Any thoughts on that right now? That's big news. This is going to be a big deal, and people are still trying to figure out the full extent of this Bostock decision. So that's important. Let's talk a little bit more about the Supreme Court. You probably already heard about this, and that is the survival of DACA. For those of you who are unaware and may have strong feelings about this one way or the other, during the Obama administration, I love the questions, and employees in the waiting room. Oh, thank you. I appreciate that. Every time, keep me honest on this. No, I've reached my limit, Jen. I can't let the person in right now unless they've managed to get into the program. But thank you for that. Let me make sure I can do this. All right. Thank you. If you're unfamiliar with DACA, this actually may impact the city of Commerce City in some respects. So, thank you. And, you know, if just as a total aside, we have plenty of time to talk about this. I really admire the comments to everybody on chat. Keep them coming. If you free up an area, thank you. Now I'm allowed to bring people in. That's very helpful. So please keep reminding me if people want to be admitted. I now have room for anyone who's trying to join us. So encourage them to try to get back in. DACA, the Obama administration permitted approximately 700,000 to 1 million persons, now referred to as dreamers, persons who as minors were brought to the United States without authorization to enter or remain, and now have reached, have been in the country a long enough period of time. The question of their status in this country was addressed by the Obama administration in this Deferred Action on Childhood Arrivals, allowing persons who came to this country as minors, obviously by others, not of their own accord, to remain in the United States, not only to remain lawfully, but also to lawfully work. We're talking about nearly 1 million people who qualify. Supreme Court ruled that the Trump administration had arbitrarily and capriciously rescinded that program, in other words, saying the Trump administration could not end that program. Recently, a federal court has now endorsed DACA. Therefore, please understand, again, this class is for managers and their employees. persons who are DACA recipients, people who arrived as minors and otherwise remain qualified to live and work in the United States, they can apply for work and they can obtain work authorization under this particular law. So they are allowed to do that. And you may encounter more and more DACA recipients who are applying for employment, and they may lawfully work. Presently, their work authorization is limited, unlike, oh, thank you. Their work authorization is limited, meaning it's for a term, but it may be renewed. So people who came to this country as minors are authorized to work in this country presently, right? And hey, thanks for putting my book title out there. I really appreciate it, Kath. Keep the questions coming about this. So you may encounter persons who are DACA recipients. Oop, hold on a second. Next one. I want to talk a little bit about the Supreme Court. I mentioned earlier, and again, I'm not trying to bore anyone with this. I just want you to know there is a method to my madness here. Please keep in mind our Supreme Court is presently constituted with the death of Ruth Bader Ginsburg and the addition of Amy Coney Barrett. Our Supreme Court is now relatively conservative in its bent. That's important for determining the future of the Supreme Court's action, especially action affecting employers, because the Supreme Court has stepped out and made some relatively conservative decisions when it comes to religious protection. The example being contraceptive coverage for employers who raise religious objections to contraceptive coverage. Supreme Court has viewed favorably. The other one is religious employers. So in this case, 2 private religious elementary schools teachers were not protected. Religious schools can require their employees to meet religious standards. This case allows potentially people to argue that their religious convictions potentially interfere with their ability to meet an employer's responsibilities, or conversely, it allows employers of religious institutions to hold employees to religious standards. So what am I saying here? Stand by. We are going to see more and more religious objections to employers coming up in the ensuing year, 2 years to address this issue. That is part of the culture war, which you're familiar with, where religious issues on one end potentially collide with other protections. We already talked about you're protected based on your sexual orientation, but there may be religious objections to some of these other protections. So that's in the standby category. More and more people arguing for religious protection. Now we're going to talk about stuff that you have to know. So I'm going to do this relatively quickly. Please remember, I give all participants the slides. I've already sent them to Jen. She's kind enough to pass those along to anybody who wants them. And nothing that I talk about in any way replaces the responsibility of you to address any issues you have that we're going to talk about with human resources, because human resources is going to be busy providing, and I'm certain city's legal counsel is going to be busy ensuring that we provide some new benefits to which our employees are entitled. This is the most important part of the class in my way of thinking. This is where I'd really encourage you to sit back, take a look at this, and understand fundamentally where Colorado is going in terms of these protections. So in the midst of the COVID pandemic, you might recall that the federal government amended the Family and Medical Leave Act, and they passed a Families First Coronavirus Response Act. You might have even taken advantage of it yourself. This was a sweeping protection, a paid form of FMLA provided to people who either were affected by COVID-19 they or a family member became sick or were quarantined, or, and this may have also affected you, or you were responsible for the care of a person, especially a child, that's daycare or school was closed as a result of the pandemic. So there was a medical basis for taking time off under federal law, and there was also a family care basis for taking time off. Well, you may or may not know, and you may or may not care, but the Families First Coronavirus Response Act, the federal response to the pandemic, expires on December 31st of this year. Barring a change, and it could happen with the incoming administration, there may be a federal continued response to the pandemic, but Colorado stepped in anyway. And so we're going to talk first about a law that occurred 2 years ago that goes into effect next year. And then we're going to talk about Colorado's new paid leaves, which specifically address not only the pandemic, but other forms of time off. So I think that the city's in good stead on both, but I want to make sure you know this because there's a ton of rules for managers here. So law was passed a couple of years ago, almost 2 years ago, and it's equal pay for equal work. We alluded to this last year in our session. What would be the responsibilities of the city to manage this? Well, no surprise, now we have rules surrounding what this means. So take the big picture first. Starting January 1st of 2021, employers in Colorado, and this does include you, employers in Colorado cannot discriminate in any way on the basis of sex. This specifically does include gender identity. So please know that sex includes gender identity. We've already established that under federal law. It's made clear to Colorado law. Or gender and any other factor, I alluded to this earlier, is, hey, I got paid less, not only because I'm female, but because I'm a female who's over 40. You're allowed to make that claim under Colorado law. And so you can use gender in combination with other things if someone believes they're being paid less than individuals who are in a substantially similar job. So please, 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 I can't emphasize this enough. This law encourages employees to go to their supervisor and certainly go to HR and ask why their level of compensation is different or allegedly different than others. It's important that people understand that. And what does substantially similar work mean? It means composite of skill, effort, and responsibility. So the job has to look similar in those areas. So let's talk about what we have to do about this. So interestingly enough, hold on a second. I keep on screwing up with my own thing. So we have a bunch of new rules, and the new rules are going to make us be attentive to people's underlying complaints or concerns. So let's do this fairly quickly. I could talk about this all day, quite frankly, and our time is so short that I don't want to confuse you, but I do want you to know what's really important in this area. So the first thing and the most important thing is, when can we pay people different amounts? The law has changed a little bit here, and it's important that you know this. So the first thing to understand is you're allowed to pay employees, and this is important for future planning purposes. You're allowed to pay people differently based on their seniority. So if you've been here 5 years and I've been here 1 year, can I pay the 5-year employee more money? The answer is definitely yes. Second one, and this potentially occurs in the city, we can always pay people differently based on merit. So if you produce 100 widgets and I only produced 50 widgets in a given period, could you pay me more based on more work or merit? Similarly, output of labor, 100 widgets versus 50 widgets, you can pay more based on production. You can certainly pay more based on geographic location. I mean, obviously, this is for perhaps employers that have employees in many more sites than you do, but you can pay a geographic enhancement where it might cost more to live or work in a certain area. You can certainly pay employees more for education, training, or experience as long as it's related to the job. That is important, and that is a contributing factor in compensation at the City of Commerce City. And you can always pay people more if they are traveling as part of their job to incent them to do that travel. What's really important about this is the bottom part of this slide is those factors I just mentioned have to account for the entire differential in wages. And I add the very last sentence here, no any factor other than sex loophole like the Federal Equal Pay Act. What do I mean by that? If you're going to pay people differently, you got to pick one of these on this slide. And you can't make it like, well, you know, he did better in the interview. I'd like to incent this person because they did better in the interview. I like them more. Things that certainly might be relevant to you, but they're not one of these things. And so if you're going to pay people differently, you got to ride the horse that's listed on this slide. It can be a combination of them, seniority, and they come to the job with additional education or experience. Those are helpful, but please remember, we don't play fast and loose with employee compensation. It's a big deal under these rules. A couple of other things you got to know about this, and it's really important. I hope you don't mind me going down in the weeds, but there's a couple things you have to know. The first thing is you can't ask any applicant or employee what they made in previous jobs. It can't be a condition of an interview. It can't be part of your interview process. You can't ask people what their prior wage rate was. You can certainly ask a candidate what their compensation expectations are. Hey, what do you think this job pays? But you can't ask anybody what they made in a previous job. We have a salary history ban now in effect on January 1st. You also can't require employees to give up their right to complain about their wages. They can't sign an agreement. They can't promise to do that. Employees always have, I actually have one of these cases right now, quite frankly. It's a big deal. And again, the law doesn't go into effect until January 1st. We're going to see if it can be resolved. But an employee was lost overtime and went to the manager and said, hey, I don't think I'm being compensated enough. And can I talk about getting an increase in my wages compared to other people who've gotten increases in the past? And the employee was 2 days later disciplined as a result, not of necessarily complaining, but that's certainly the appearance of things. Is it looks bad when you come down on people who've asserted that they're not being properly compensated. So please know that employees have the right to discuss their wages. They have a right to discuss their wages with you. And certainly if there is a conflict, they should be directed to human resources immediately to determine if they're being properly compensated or to address their concern. That gets me to the HR heavy lifting of which you have to be aware of. And there's a lot of rules here, and I will not read them to you, but I wanted to give them to you. So Colorado has a very ambitious equal pay law. They now have a couple of notice requirements that no other state has to this level of depth. The first thing is we have to let employees know what promotional or advancement opportunities are available to them. That is, all opportunities for promotion or advancement have to be communicated to employees by the city. We also have to inform individuals of any job openings, and this has to be reasonably communicated to not only the public, but also to other employees. And that job opening has to give a general description of what you get in that job, what's going to be the compensation, what's a description of the benefits, and all other forms of compensation associated with this job. You're already doing this at the city, so I'm confident that the city, well familiar with this rule, is going to help you managers. But please know that people have to understand what is out there. So these are busy slides. I wanted to give you all the rules because I wanted you to see them. A lot of these rules pertain specifically to human resources, but they answer a lot of questions that I get. And I answer a lot of questions that managers have been asking me. So when I talk about what has to be in the posting, I'm talking about what is the hourly rate of pay or what is the salary or a range of the salary for this job. You also have to include any bonuses or commissions that are available and what benefits. What do I mean by benefits? That includes, do you have health care? Do you have days off? Do you get vacation? So you generally have to tell people what they get in these jobs. The next question I get is, well, what kind of salary range can I post? Well, here's what it says. You can extend from the lowest to the highest range in a position. Someone asked me when I taught this class a year ago, actually, someone asked me, can I just post to the midpoint? So salary starts at, $35,000 a year, and the midpoint, not the maximum, the midpoint is $40,000. Can I post a range of $35,000 to $40,000? And the answer is technically no. Is you have to go from the lowest to the highest rate of pay that you in good faith might pay for this job. So that's down in the weeds, but I want you to know you can't play fast and loose with compensation under this rule. That goes to promotional opportunities. This is a big deal. What I mean by promotion is anticipate a vacancy. Yeah, we're going to make the PowerPoint available. I would never expect you to memorize any of this. And by the way, you shouldn't want to memorize any of this. You should just be listening for things that might be attentive to your job. So for example, I got a lot of questions about this. Hey, what do you mean by promotion, Chuck? We have people who are essentially promoted in place. They go from level 1 to level 2. Oh, I love it. I'm getting good questions. Hey, why couldn't we post what we're authorized to hire at instead of the entire salary range? What I have to tell you is you are allowed to post, quote, the salary. You don't have to do a range. You could say this job starts at X salary. So you could potentially do that. That's a great question. I appreciate that. In reference to the posting requirements for 2021, was there something close to this requirement in 2020? No, but employers were leaning in and they were already starting to adopt these rules in 2020 to get ready for 2021. Love that question as well. Keep these questions coming. They're very relevant to everybody listening. So I do want to talk a little bit about this promotion thing. The only important thing on this slide that you need to know, because I decided to give you the entire rules, is it has to be a vacancy. So if someone basically is elevated from a technician 1 to a technician 2, a time in grade promotion, that may not be a, quote, promotional opportunity because that's simply a step or grade increase. So don't go crazy on me when it comes to giving notice of all promotional opportunities, because that may not be, quote, a vacancy for anyone else to contend with. The other thing is you got to notify all employees of all promotional opportunities. You can't limit to those people that you think are qualified. So it's important. Now you can say this job is only available to certain people with these qualifications, and we can certainly screen out candidates, but you got to let everybody know about these promotional opportunities. Can't play fast and loose with promotions. It's important you know that. Let's keep on going. Keep the questions coming too on chat. What do we not have to post as far as promotions go? I want you to see this. They created 3 exceptions that were not in the law that might be beneficial to the city. The first one is, what if it's a promotional opportunity that we have to keep confidential, that it's the incumbent person is, we're not going to disclose this because the person has a high level position. Therefore, it's a confidential job that's being held open. There may be room for that. This is actually going to be where you need legal advice from your own city attorney's office about what is a confidential position. The next one is automatic promotions, where people start jobs typically in the early stages and they move into, I love the question here coming up, does that include reclassification of a position? I have to tell you, I'm going to do all these questions. They're fantastic. So reclassifications of positions may not be a vacancy. And so it's going to be a question of, is this viewed as a promotional opportunity or not? Does it matter the order of the posting of the salaries? As long as the full salary is on the posted somewhere in the job posting, as long as you have that salary on there, there's a safe harbor there. So that's good. I like the question. Is you got to tell people what the compensation is for that job. And you may say that there is no specified range, and this is simply what the starting salary is for that position. The next one that you don't have to post for is temporaries or interim hires. If it's going to be a temporary job, then that is then not expected to be a permanent job. Then that really isn't a promotion when someone necessarily gets that job or goes to a regular job after that fact. So there's some room here. This is an important slide for HR as far as what we would or would not post for, but I wanted every manager to see this. Again, I'm going to get way down in the weeds on this. Got to post for every job that's available in Colorado. And of course, every job for the city is a job that is available within the state of Colorado. So there's no exclusions for you. There are exclusions for people who have jobs who are Colorado employers, who have employees outside of the state. Hey, can employees talk amongst each other regarding their salary after being hired? That is an awesome question. Colorado law now makes very clear that I love your question. I wish it was a question to everybody, but I'm going to repeat it for everyone. Colorado law makes very clear, and this, by the way, is already within federal law under a law called the National Labor Relations Act, which doesn't govern you. Employee salary discussions are protected, meaning, and I love your question, it's why I love us talking about this. Employees have the right to get together and talk about whether they're being properly compensated. Please know that. It's important for people to realize that's an important consideration under these rules. You're allowed to do it. What's the exception to that rule is certainly if those discussions are interfering with work time or work responsibilities, then that would be a potential area where a manager could say, hey, you got to take this offline. You're interfering with work right now. But where employees are on their own time, especially off duty or online, perhaps, they are allowed to discuss their own wages with each other. That's important that you know that. Next one, I love the questions that are coming along. Can we still internally promote without posting a position, or do we have to at minimum post internally? You're gonna, even if it's an internal, you're gonna have to post that notionally under this rule. It's important that people know that, unless it's not a vacancy, but simply a step increase, where someone goes from technician A to technician B, then it may not necessarily be a quote promotion. Considerations for us. I have to tell you, there's a huge record keeping requirement here. We have to keep records of all, not only job descriptions, but the wage history for our employees for the past 2 years. There's a ton of ways to complain for people to do that. Please know that not only can people file a lawsuit, which this law certainly encourages, but they're allowed to file a charge of discrimination with the Colorado Civil Rights Division. They're allowed to complain to the Colorado Department of Labor and Employment. So please don't be surprised if a state government official does show up asking questions, if someone went to them and complained. Please direct all of those complaints, or if you learn about a complaint, immediately to the city attorney's office for the adequate response, and of course, in conjunction with human resources. HR already knows this. You don't need to know this. There's a little bit of a safe harbor if you do a comprehensive pay audit of all of your jobs to ensure there is no disparity on the basis of gender. There is room for employers to at least not be tagged to the full extent of damages under this law if you make a good faith effort to audit for any wage disparity. So we talked about this slide last year. This is really a slide for the employer in the collective, all of us, is we have to, and the city's been doing this. That was the comment that was raised in chat earlier. We've already been doing this as far as notifying about job openings and promotions, but it's going to go into full effect on January 1st that we have to comply with Colorado's law in this area. Any questions about equal pay? I saw a lot of them coming my way. Keep them coming, but I told you there's a lot to talk about this time. This might even be more relevant for you at the manager level. So I already talked about the response to the pandemic from the federal government. Colorado also stepped into this, and Colorado passed 3 separate paid leave laws. Oh, good. People are coming in. If I have room, I'm letting people into the program. So thank you for joining us if you just arrived. And again, my apologies for the cap on the number of attendees. Didn't quite realize it was that 100 threshold. Let's talk about this. This is something, and this is of course, your all employees who are listening right now. Not only should you know this, but you may be responsible for managing this. And it's important that you're aware of it. So Colorado in its legislative session this year, even in the midst of a pandemic, passed these 3 separate paid leave laws. One of them I'm not going to address in great depth. It is an emergency paid sick leave law that expires at the end of this year. This was essentially the Family First Coronavirus Response Act requirement extended to employers that were not covered by federal law. And that does, it should actually be December 31st as a typo on my part, but that does expire here at the end of the year. The 2 that you need to know about that are going to require your attention and are a little bit different than past leaves are Colorado's paid sick leave law and Colorado's public health emergency leave law. Should also share with you, and this is really important. In addition, Colorado passed a Paid Family and Medical Leave Act law, made part of our Constitution, in fact, in the last election this past November. That will go into effect in 2024. That will also have to be connected to these particular provisions. More on that a little bit later. Again, I told you, it's a lot to talk about. Sit back and relax. I don't know if we've ever had a session with this many new rules in it. So the first one is, starting January 1st, all employers, at least all employers with at least 16 employees, have to provide paid sick leave. Now, the city already provides paid sick leave to its employees. But this is why I want to deconflict and make sure we're deconflicting the city's paid sick leave with now the requirements of Colorado law. You're very adept at doing this, but I want to make sure you know what your responsibilities are in managing this. So now to Colorado's new law, every employer that's covered by this law, and by the way, starting a year from now, January 1st of 2022, all employers with at least 1 employee in Colorado are required to provide paid sick leave. But certainly you are in the covered employers for next year because you have well above 16 employees. But here's how it works. Every employee working in Colorado is going to accrue paid sick leave 1 hour for every 30 hours that they work, up to 48 hours. You might even hear this every once in a while referred to as 6 paid sick days. So 48 hours for a full-time employee essentially equates to 6 days off. And so you have to get, and I use this reference a lot, 6 days of paid sick leave each year under Colorado law. What's changed and what may be a little bit different than the city's policy is the employee starts to accrue it from their first day of work, or if they're already employed, like most of your employees right now, starting January 1st, meaning starting January 1st, employees are going to accrue this benefit. That's a big deal for new employees because many employers, you don't earn sick leave until you've worked for a period of time. Well, now our new employees and our employees that we already have are going to get this paid sick leave relatively early in their employment, about 30 hours of work into it. You can front end load the entire 6 days. You're allowed to do that beginning of every year. You just give people 6 days. You can certainly be more generous. So you could give people 10 days, but maximum 48 hours. I love it. The question is, the accrual was all year. The maximum is 48 hours. This is correct. So you get 48 hours total in a year. You could always be more generous. You can always accrue at a more generous rate, but you only get a total of the 48 hours. So by way of example, this is the question that's coming to me is, our employees are going to start to accrue on January 1st, every 30 hours of work, 1 hour. When they hit 48 hours, they have reached their maximum to which they are entitled. Potentially you can give them more, but that's going to be the maximum that they can accrue and use. You could always let them go more. The city may elect to do that, but under state law, it's that 48 hours, and then you have your benefit. You're allowed to carry it forward though. So for example, many of you are not sick in any given year and rarely use sick time. Then you're allowed to carry forward up to 48 hours, which is the accrual maximum. So it's 6 days. Now I love the question that, why is this a requirement if a company already offers PTO? There's a provision about this, and you need to know it as a city. If you already provide PTO, so if you're an employer, as you are, that already provides PTO and sick leave, you are allowed to count that as this benefit. In other words, that is the accrued paid sick leave. But I'm going to talk about that because if you have PTO, if you have a general sick leave, the change here is you have to allow your employees to use your paid sick leave or PTO, whatever you currently have, for the same reasons that Colorado law allows, which are very expansive. That's why I love that question. It's good to have a PTO policy right now, but you may have to expand it. Is this also for part-time employees? Absolutely. Part-time employees accrue. Again, they may accrue it slower because they may not accrue 30 hours. It may take them longer to get 30 hours, but they also get this. And then our general leave is for both vacation and sick. Is this still a requirement? You can have a PTO or general leave for vacation and sick. But what I want to clarify is for sickness purposes, you have to allow all the uses that Colorado law allows. This is important. So I love the fact you have a general leave, but you're going to have to allow it. Managers, this is super important for you. There are new ways to get leave under Colorado law that you have to be aware of. The question here is there a difference between general leave and paid sick leave? General leave is typically much along the lines of paid time off or PTO. General leave is typically a combination time off for any reason, vacation and or illness. That's important that people know that. And then I have a question about VHE employees. Please clarify on that, what you'd like to know about it. Does the sick leave carry forward? Did you lose it and have to start reaccruing? It can carry forward. It carries forward if you do not use it up to that 48 hours in subsequent calendar years. So, the part-time employees, they're going to get this benefit. Please know. We'll talk about an exception to that in this rule, but part-time employees are generally covered by this. This is why I loved your questions. This is why I loved us having this session. This might be the most important slide this is applied to seasonal staff. Now we're going to talk about that, is that if these are employees who are on your payroll, who they may get the benefit of this particular law. And we'll talk about the exception of that as we go through the exceptions. This is the most important slide though. This is so important. So as we've already established from your excellent chat comments, that's why I love us doing this. You can have you can have a general leave. You can have what you have right now. You can have PTO. You can have sick leave. What you have to do, though, is you have to allow your sick leave to be used for these reasons. Why is this a big deal? Look at the reasons. The first two are pretty easy. Your employee has a physical or mental problem, illness, diagnosis, needs time off to get preventive care. You already give sick leave for that. That's not hard to comply with. The next one is if an employee needs to care for a family member, you also potentially permit that. So if you have a child that's sick and you use sick leave to care for your sick child, that's also permitted. Talk a little bit about what family member means in just a second. That's been broadened. But here's what's new. This is what I want every manager at the City of Commerce City to realize. I know you're all over this, but this is a big deal, is that under Colorado's paid sick leave law, meaning if you have PTO, if you have sick leave, if you have any combination of those things, you have to allow up to 6 days off. You can always do more if you allow more. You have to allow up to 6 days off, or look at the third bullet down here. Employee or their family member has been a victim of domestic abuse, sexual assault, or harassment, needs to be absent from work for purposes related to such crime, such as getting law enforcement intervention, getting a temporary restraining order, getting psychological or medical care or counseling, getting a lawyer to potentially address the concerns you have about that. That is often referred to as safe leave, to make a victim safe from harm. That is important that you realize that. This is new to Colorado law. We already have a law that says you have to give up to 3 days for safe leave. That has now been increased to up to 6 days can be used for victims of domestic abuse, assault, harassment, crimes based on sexual harm. And so your policies are going to have to encompass that. Same with the pandemic. Look at the very bottom bullet. If a public official orders closures of a business, school, childcare, which of course is happening right now, you can use paid sick leave for time off in a public health emergency. So starting January 1st, if the pandemic continues, as it most likely will, employees are going to be eligible to use City of Commerce City paid sick leave for these types of public health emergencies. That's important. Those last two bullets are changes to many employers' current sick leave policies, and you're going to have to conform. So if an employee comes to you, this is a big deal. This might be it. All I need you to really know. If an employee comes to you, managers, and says they need time off because their kid's school is closed, or they need time off because their family member's been quarantined and they need to provide care to them, or if they need to, or they've been quarantined, or if they have a family member who is a victim of some assault, then it's important. Yeah, I love the comments that are coming, and I think people do approve these. Thank you for sharing that with me privately, is I think a lot of people think that these are important for individuals to have these protections in our society. So thank you. I tend to agree that many states have these protections. Colorado now includes them. I'm getting a great question privately. What can employers require in documentation for proof of these situations? Well, this is going to surprise you. It's limited, and that's also different than your current sick leave policy. So this is a very employee-friendly law. And so it's important that you understand this. Keep the questions coming. So a lot of things that I think I've already gotten in your chat, but let me make sure I hit them all. So the first thing is, if you're an exempt employee, like many of you, you basically, how do you accrue your sick time? You're presumed to work 40 hours a week. So you're going to start clipping along, accruing like an hourly employee in many ways. You can use your sick time in at least hourly increments under this rule. So if you need to go to a doctor visit, can you take an hour of paid sick leave? That's okay. What if they haven't accrued the time? Do we have to approve their leave? You don't. That's an important question. Now we'll talk about accommodation issues. If someone has a disability and they don't have paid sick time, and it might be a reasonable accommodation to let them take the time off, that might be something I would entertain. But under Colorado law, if they don't have the accrued time, you do not have to authorize the leave. Again, please, in particular, keep your questions coming. They are very spot on. Employee must make good faith effort to provide advance notice of foreseeable leave. So that goes back to what notice can we require? I love the questions I'm giving. Once an employee uses 48 hours, it'll be tracked. Can the city start asking for documentation for the balance of their general leave? The answer is technically yes. We'll talk about that. In fact, this is important. Here's the rule. That's why I love your questions. Here's the rule. Employer can require reasonable documentation for any leave lasting 4 or more consecutive days. So if an employee starts to use chunks of this, now, what's really important about that is please remember under existing sick leave policy or general leave policy, we could ask employees for a doctor's note after 3 days, after 3 non-consecutive days, 3 days for the same condition. Colorado now makes that you can only ask for documentation for leaves lasting 4 or more days. That is really a constraint. Now, please remember, a lot of you are super smart about this, and HR is all over this. If the absence is an absence that's also covered by the Family and Medical Leave Act, which the city also supplies to its employees, we are still allowed to ask for the medical certification forms for any employee who's taking family and medical leave. So please, this is important. I love the question coming around. Is 6 days off realistic if schools shut down due to public health order? Hold that thought. Again, great question. There's another leave tied to that. So we're going to talk about that. There is a new Colorado law which mirrors the Family Forced Coronavirus Response Act to some degree. But 6 days off is not a lot. I appreciate the comment. If your school's closed, school's probably going to be closed for more than 6 school days. So we're still going to have to address on a case-by-case basis employees who are attending to children whose schools or daycare facilities are closed. Don't have to pay the leave upon termination unless the employer argues it was deprived of them as some type of retaliatory act, or unless the employee is reinstated. And you can't make any employee find any type of replacement or coverage if they're taking sick days. You should know that already as a manager. You can't force employees to find coverage if they're sick. This law makes that clear. Please don't be tempted to do that. Is this paid sick time only for the period of COVID, or is this a permanent requirement? Oh, awesome question. The answer is this is a permanent requirement. So this is going to be the law of Colorado forever unless it is repealed. So it's not, it was prompted by COVID, but it certainly goes beyond COVID. Person asked me in a great question, what if schools shut down? Is 6 days going to be enough? Well, there's another provision here, is in the event of a public health emergency, such as this pandemic, the employee is entitled to supplement up to 80 hours. This is paid. You have to give an employee 2 weeks one-time emergency leave if it's a part-time employee, proportional to their 2 weeks pay, to tide them over during a public health emergency. That's why I really appreciated the question on chat. Is 6 days off realistic if schools shut down? No. Colorado's got another leave that you have to afford employees, and this could happen. That's why I love your question. This could happen come this, this winter, this 80 hours of paid leave. You can offset accrued unused paid leave. So for example, those 6 days you already have, those are going to count towards the 80 hours that you get. But please be attentive to this. This is brand new. Is obviously the employee has to notify you of this need as soon as practicable. And I'm getting great questions privately. Hey, if you front end load the hours, let me just make sure I go up to this provision. If you front end load the hours, I'm gonna make sure I do this. Hold on a second here. Again, just my chat. Yeah, if you front and load the hours, do you front load 1 hour per 30 or the total bank? Great question. Employers have been front loading the entire amount. That is the plan. So for example, for 6 months, you front load 24. Many of my employers are front loading the full 48. What's the danger there? That the employee may potentially use more than they accrue, especially if they leave their place of employment. You may have no way of getting those funds back. But a lot of employers, especially for long-time employers, are front-end loading the entire amount. Could you front-end load? The question on chat is, could you front-end load a proportionate amount? The answer is yes. So for example, for the first 6 months of 2021, we're going to give everyone 24 hours that they can use. That is within your prerogative to do so. You can also use your existing sick leave policy. As long as you accrue at least that 1 hour per 30 hours, you can do that as well. Again, these are awesome questions. I'm gonna try to get everyone because, beyond this, there's not that much else you need to know about it. In order to be eligible for the 8 hours, what about quarantine orders? Quarantine orders are going to count towards this potentially. If it's a public health emergency, that person needs time off because they have been quarantined, they are going to get this particular paid sick leave benefit? That's a great question. Again, in order to be eligible for the 80 hours, did an employee need to exhaust all their other available general leave time? No, they're going to get that 80 hours. You can count what they already have, what's accrued, but towards the 80 hours, but they're going to get the 80 hours. It's a one-time shot. And again, it's one time during their entire employment is, barring a change in law, it's going to be a one-time benefit. Hopefully all these make sense. Starting when? January 1st. Please keep in mind and keep your questions coming because they're all relevant to me. Here's the emergency leave. Someone asked about all of these issues. Is I get a quarantine order that's self-isolating due to a positive diagnosis or symptoms, or a doctor says you should quarantine. Someone asked that in chat. Public health official determines it's unsafe for people to come to work. That's been happening. Have to use it because your child care facility is closed, or you're a vulnerable person, and therefore it would not make sense for you to go to a place which has a pandemic. Those are the 4 reasons why you can use this public health emergency one-time leave. Then of course, I love the question, what if an employee is ordered to quarantine more than once? It's happened, is you only get the 80 hours. So it's 80 hours. So since the question is not 80 hours per, so it's a one-time 80 hours. Now, Colorado could require this again years from now for another pandemic, but it's a one-time utilization. For clarification, if you do the math, 1 hour per 30 hours for full-time employees is 34.66 hours, not 24. I agree. We have new employees who don't get leave. If we front load, wouldn't we have to front load 35, not 24? That could well be the case. I love that math question. And I agree with you logically. If you're talking about full-time employees, that's why a lot of my employers are actually front loading the larger amount, if not the entire amount, and taking the leap of faith that people aren't going to leave before they've accrued the entire amount. Hey, if we can arrange for them to work from home, do we have to provide the leave? That's a great question. Keep in mind, it's got to be voluntary. But if you can arrange for someone to work from home, remember, they don't need to take leave. So again, I like the thinking outside the box is if you don't need the leave because you're being flexible about work arrangements, that is a way to address an employee who has this. I got your point on the private chat. I took that you meant for the first 6 months. You're probably going to want to make it at least 35 hours because that really would be the full accrual for a full-time employee. I'm with you. That's probably what I would set if you wanted to front end load 6 months. So I endorse that view. Hey, if someone exhausts their 8 hours of COVID leave, and I don't mind calling it COVID leave because that's a good point to raise, due to quarantine, then they contract COVID at a later date. What are their options? It's going to be general leave or potentially as an accommodation, some unpaid form of personal leave that you might extend. Again, these are awesome questions. You know what I like about it? We should all be talking about this. If COVID looks like it's going to go, another 6 months at least, we're going to get more and more people who are going to be needing significant leave. And again, we don't know what the federal government's going to do, but it's important that you understand this. Let me do a couple quick points. Your chat questions have been amazing, but I want to give you sort of some other rules. And I'm not going to read all of these rules to you, but you've already asked so many of these. If you don't use some of the sick leave and it carries over to next year, does it continue to accumulate and carry forward year to year in excess of 48 hours? Not necessarily. You can put a cap of 48 hours on this should you desire to do so. It's a good question on private chat. If the employee resigns or is dismissed from their position, do we have to pay out the leave? Not this leave. Not paid sick leave. You do not have to pay it out unless they can argue you deprived them of it when they were employed. That's important. So please keep it in mind. And then there's a private chat going on about, hey, if you want to front end load, you know, if we're talking about 24 hours versus 35 hours, it really is sort of addressing at the accrual rates. So that's a good HR conversation to have. This slide talks about you. Remember, if you already have accrued paid leaves, you can keep your current general leave policy that you have as long as you provide comparable time off, meaning you got to give people time off for the public health emergency provisions. You got to give people time off for so-called safe leave. You can keep your existing policies in place as long as you do not give less than state law requires. Let me just mention this quickly. I love your questions, actually. You're awesome. Hey, can the city implement a testing program they pay for to avoid extended quarantine leave? Can the city require an employee to take a test? We're going to talk about that. And that was a question for everyone. Hold your horses. I got an overview of that. We'll talk about what kind of testing you can have. Currently, employers can viral test. Antibody testing, according to the Equal Employment Opportunity Commission, would violate the Americans with Disabilities Act. So testing generally for antibodies without showing some demonstrable business related need for that would be a problem. Viral testing to test if somebody has COVID is been explicitly permitted by the U.S. Equal Employment Opportunity Commission. And so this is amazing. God, and I'm going to give Mike credit. That was a public comment. Hold that thought. I put a bunch of rules in here, so you don't need to read these, but I thought I would give you all of the rules that you could read at a later time. It's the accrual starts when you start to work. A couple things about people who have irregular hours. It already mentions the year is a calendar year unless you change it. So it's 48 hours a year. You got to pay it the same way you pay your other benefits, which is important that you know that. So as long as you're accruing your benefits, you're going to still accrue them while you're taking paid sick leave, which is obvious. That's what you do now. But it's going to keep maintaining the same. That way, you don't hurt people, at least in their benefits, for taking paid sick leave. You can never count paid sick leave in a performance evaluation or any attendance policy, much like family medical leave. You can't hold it against people. I want to get to your questions, Mike, about can we test, though? That's really important. A couple of other rules about this. We already talked about how do we apply existing leave policies towards, it's called the Healthy Families Workplaces Act, is Colorado's new paid sick leave. I call it HFWA, HFWA. So it's how do you integrate paid sick leave that you currently have into this? And then finally, this is what people have been asking me. What is the documentation that we can require? It is very limited. It's 4 or more consecutive days. The employee only has to give you information from their healthcare provider. We can provide a form that the employee took leave for a qualifying purpose, but there's not a lot of room here in terms of what documentation we can get or how we challenge an employee's documentation. Very favorable to your employees. Please know that. Demanding extensive documentation requirements might be a fool's errand if we're going to provide people their paid sick leave properly. Here's the record keeping requirements, or if you have a collective bargaining agreement with any of your employees, that's on the table here. Then I have to tell you, you thought this was a crazy year. It only gets better. Is Colorado passed the Public Health Emergency Whistleblower Law. I call it PHEW. Here is important for you to know, and I know you know this already because safety is a concern. We were talking about at the beginning of class, is Colorado now made it part of state law that employees have the right, without any discrimination or harassment, to raise any concern related to their health or a risk to employee safety during any public health emergency or disaster. Please know that. And that specifically includes concerns about wearing PPE or not having adequate personal protective equipment. Please know that. Managers, I know you know this already. You're covered by this law. Is employees essentially have a right to come to you now and raise concerns about their health, protected under Colorado law. This is a very strong new law with extensive enforcement requirements. I would not want to see the city of Commerce City get swept up into this, but there are extensive enforcement rights under this law. So just know this: if employees raise concerns about their health, about their safety, we have to get that to our safety personnel. We have to address their safety concerns, as I'm sure you would and have been doing so for the past 9 months. But there is a new law on the street, which also goes into effect, and it's important that people know that. January 1st, 2021, protections for complaining about health during a pandemic. Have to have a poster up there. You should probably already know that. Have to give all employees notice of their protections under this law, which you will do. Written notice requirements. If you have a handbook, you have to put a provision in your handbook, or you have to potentially give everyone a written notice. You can do it electronically of their rights under this law. And if at least 5% of your workforce speaks as their first language, a language other than English, you have to put these written notifications into that other language. Getting these great questions. The days of coming to work sick have passed. With paid sick leave anti-whistleblower law, can you make a visibly ill employee go home and use sick leave? The answer to that is yes. Please know that if employees present to you with symptoms or say they are not feeling well, you can make an employee go home. You do not, I love this question. I love this question. You can make an employee go home and avail themselves of these sick leave benefits because we don't want to risk contagion of others. Okay, keep on going. All right. You're not covered by Colorado's comps order, thankfully. I wanted to put it on the table here. You're going to hear about this. Private sector employers are covered by Colorado's comps order, which is the overtime and minimum pay standards. I wanted you to see it because this is a law that is raising the state level of compensation for exempt employees. Next year, exempt employees covered by Colorado's law, this is not the city, but you may use it as a comparator, have to be paid at least $40,500 per year if they are going to be exempt employees in Colorado. This law does not cover, this provision does not cover City of Commerce City. You'll notice the state minimum wage is going to be $12.32 per hour. Question, so we're covered by the Constitution, though, requiring minimum wage. You are indeed that, and this, of course, dovetails with that. So City of Commerce City does have to follow Colorado's state minimum wage requirement, which this is the $12 an hour increased by the cost of living increase. And so you do have to follow Colorado's state minimum wage. Paid FMLA. If you think paid sick leave was tough, hang on to your horses, because Colorado is going to have a paid family medical leave benefit. So you already know we have family medical leave up to 12 weeks off for family or medical related reasons. Colorado, starting in 2023, is going to start collecting premiums from employees. And in 2024, much like unemployment benefits, is going to start paying employees who qualify for paid family medical leave, which does include, unlike the Federal Family Medical Leave Act, an additional 4 weeks off for pregnancy and childbirth related complications. So you are going to get more than 12 weeks for the condition of pregnancy and childbirth. It does include those safe leave provisions that we talked about under Colorado's paid sick leave law. A couple things about this. What's really important for you is this goes into effect, and you can read this now, it's going to be a generous unemployment-like benefit, but what's important for the city to realize is the second to the last bullet here. Local governments, that is you, that already provide paid family medical leave benefits similar to this can opt out of the state law. That is something that the city is likely to consider over the course of these next few years. What if the employer has short-term disability for paid time during FMLA for full-time staff? That's going to be the issue. I love that question to me is local governments that have paid disability benefits that cover all of those provisions of paid FMLA, including safe leave, are likely to already have this benefit in hand and can opt out of the paid family medical leave. It's important that people know that. So thank you for throwing that out there. Employees can still opt out of the program even if the employer opts out, so have to administer. It's true. It's going to be, the question about the employee is this for part-time staff? Yes. You'll notice that the part-time employees are potentially going to be covered as well in this regard. That's important that people know that. And really the question about whether people can remain in or opt out has got to be solidified. We are going to get rules on this long before this law goes into effect. It's important that people know that. Let's keep on going. A couple quick things, because Mike asked me an awesome question about what can I do about the pandemic. So the hot question right now is, what is the Biden administration going to do about marijuana? I put this slide together that once again in 2020, 4 more states added recreational marijuana: Arizona, Montana, New Jersey, South Dakota, a relatively conservative state, and now allow for recreational marijuana, and 35 states allow for medical marijuana. So a lot of states are permitting marijuana to be used or decriminalized in their state, which is putting upward pressure on the federal government to consider taking marijuana off of the Controlled Substances Act. That's going to have a big impact on employers if that happens. So please stand by for more on that, which we may be talking about next year, but I call it really the growth of marijuana. Mike asked me a question I put together for your consumption, what I consider to be the federal government's current take on pandemic guidance. So thanks to your questions, you asked a number of these things. If someone has symptoms, says they have symptoms, we can make them stay home. If they present, we have to keep confidential that that person potentially has COVID-19, but we can make them stay home if we believe they've been exposed or have symptoms to COVID-19. We potentially have to accommodate people who are vulnerable or potentially have been exposed, so keep that in mind. Testing is dicey. There's 3 testings I want to talk about, and I really appreciate the question. So according to the federal government, you can't require antibody testing. Does someone have the antibodies to COVID-19, which would make them potentially able to fight better or resist better COVID-19? That's a medical exam that you can't require people to do unless it's required as part of their job. That might work in a healthcare environment or setting, but not necessarily for every employee. You can require a viral test. So if we require employees to go home due to symptoms of sickness, are we placing liability on the ER for diagnosing our employees as being sick versus possible allergies? It's a great point. We're putting liability on the employer. Well, this is one of those things, better to proceed with caution than in error. And so, yeah, it could be a misdiagnosis, but we're protecting the entire employee population. So even if we're wrong, it may be allergies and not COVID-19. Employers can still require employees to go home, and we could still employ employees to get a test. Do they have COVID-19? That is lawful. Please keep that in mind. I would consider paying for an employer mandated test. That's important that you do that. Obviously, we can require employees to wear protective gear. The third test I wanted to talk about is, and you already talked about it, this is a huge hot topic, no kidding. The third thing I want to talk about, and Mike didn't ask this question, but I really think he was leaning in this direction, is what if we get a vaccine? Can we require employees to get a vaccine? This is going to have to be on a case-by-case basis, and it's going to be directly related to what the employee does for the city. And you're going to have to consider, and supervisors, you're going to have to consider with HR and legal, if employees want to opt out of a vaccine for religious or medical reasons. That's important. So we have to balance safety with an employee's rights or potential objections to vaccines. I think a lot of people, my own personal view is, if the vaccine does become available, I would certainly consider making the vaccine at least voluntary at first, unless the employee's job, such as a police officer, involved direct care and contact with members of the public. Then that's going to be an easier requirement if we are going to potentially put people into harm's way. There's a lot in these two slides that I wanted you to take a look at, and added on top of the federal government's look at this, I also want to get a couple things off my chest. The lawsuits have already come in. Is what about employees or members of the public who refuse to wear a mask? What's the current state of law there? I don't know if you saw on the streets this, I call it fake mask card. This has already been debunked by the federal government. There is no such agency which issues this card, but we've already gotten our first lawsuit this year where a member of the public refused to wear a mask and said it violated the ADA to require him to wear a mask, and he lost because the employer could reasonably require employees or persons entering a grocery store to wear a mask. And there were many other ways to accommodate someone's medical condition, such as, hey, you can pick up your groceries in a car outside. We have curbside service. You can wear a face shield if you can't wear a mask. You can get home delivery or hire someone to do your shopping for you. So please know that this is a huge area. Can the city test all public works employees, say every Monday? The city could test employees by department. Public works, obviously, critical functional responsibility of the city. You could do that. Obviously, you could do it on a periodic basis. And many, like for example, many organizations are doing this right now. I was just talking to a friend of mine whose kid goes to college in some college where they test the students who are still present weekly for COVID-19. That's a requirement to stay on campus. So remember what I said, viral testing, as long as you're not singling out people based on any protected category, we can't say all 65-year-old or older people need to be tested necessarily. We can't single out people who are in protected groups, based on that. But if you're going to do it across the board, you could potentially do that. What if we require the vaccine and then later find out there are permanent side effects? That's going to be a workers' comp issue. If there are people who are harmed potentially by a work-related requirement, we're going to see those cases. There are already workers' comp cases coming up with COVID-19 as far as exposure goes. So there is going to be potential liability issues with regard to not only the pandemic, but the vaccine, if it does cause harm in human beings. So far the studies are promising in this regard, but vaccines can potentially cause harm. I appreciate the question. Please keep in mind, I'm going quickly because there's a few more things to talk about, and I won't talk about all the cases, but I will talk about things that you need to know. Colorado's already stepped in. Please remember, you do have to consider accommodating so-called vulnerable individuals. So if a person says they are pregnant, such as an pregnancy is compromising of your immune system, or they are high risk, you do have to be attentive to those employees that are vulnerable. And I give some of those vulnerabilities right here. And please direct any person who requests an accommodation, especially any vulnerable employee, to HR for consideration in this regard. That's important. Affordable Care Act is on the table right now. You probably saw this recently. The Affordable Care Act oral argument was heard. The Affordable Care Act, so-called Obamacare, has been challenged a number of times without success until recently. Is once Congress changed the Affordable Care Act and took away the so-called penalty associated with the individual mandate, a number of states jumped in to say, hey, it's no longer a tax, which is the reason it survived earlier, famously, is now there's an open question about whether the Affordable Care Act will fall because it no longer meets that threshold. I listened to some of the oral arguments. There's a real question about the concern if the Affordable Care Act is done away with in its entirety. So they may try to cobble together some solution to the Affordable Care Act. Many people view the Affordable Care Act with disfavor. However, many people don't. And what's really popular about the Affordable Care Act, the why this has been a tough nut to crack politically, is people really like the Affordable Care Act does not have the exclusion based on pre-existing conditions, meaning you can gain insurance even if you or your family members have pre-existing conditions. That's why there's been no viable alternative to the Affordable Care Act that's been proposed by any other members of Congress because of that popular provision. This is a non-political statement. That's why that is a tough law for people to try to unravel, because some parts of it, a lot of people like. Federal government stepped in about doing unconscious bias training. Only covers contractors, so I won't talk to you about that. Please keep in mind the EEOC came out with guidance on dealing with employees who have addictions, including opioid addictions. You cannot use opioids unlawfully. That's clear. But if you have underlying conditions where opioids have been prescribed to you and you're using them properly, an employer does have to consider that employee in their accommodation requests. Do the last few of these things. New things on the street from the Department of Labor. You could take a look at that in your own time. That's not important that you realize that. The last thing I wanted to talk about was what I started with. And then I'll show you the rest of the slides if you're interested. But I want to talk about a couple things because it's been a difficult year for a lot of people. And what I'm going to conclude my remarks on is this issue of employees speaking out publicly. So big case came out this year, Marquardt. You might even remember this case on some level, at least the underlying basis for it. So Captain Marquardt worked for City of Cleveland Emergency Services, and he got fired because after, you may or may not recall the case of Tamir Rice. He was a 12-year-old boy who was pointing a pistol at people at a Cleveland recreational center and park, acting out of control, and the police responded to the scene and actually shot and killed Tamir Rice while he was pointing this pistol. After the shooting, it was discovered his age was 12 and the pistol was a toy. That's not necessarily, police officers still confronted with a potential threat. What made this case was Marquardt goes on Facebook inexplicably 14 months after the shooting and says this quote, "Let me be the first on record to have the balls to say," mind you, we already know it's a 12-year-old kid at this point in time, to have the balls to say that Tamir Rice should have been shot, and I'm glad he's dead. I wish I was in the park that day as he terrorized innocent patrons by pointing a gun at them, walk around like I'm acting bad. I'm upset I did not get the chance to kill the criminal F word. pretty over the top, I think. And interestingly enough, he got fired for it. The question, though, became, is that a matter of his free speech? And he challenged, this is off-duty speech, he challenged the decision to fire him. And the appellate court this summer ruled that he will have his day in court. I don't know if he's going to prevail, but they said, hey, wait a minute, you need to know this, managers. People say provocative things. I don't excuse what was said here, but I want you to know the law in this area is that when employees are speaking as private citizens, Captain Marquardt had taken off his uniform and he was on Facebook, on his personal Facebook account. When public employees take off their uniform and they're acting as private citizens on matters of social concern, in this case, the court specifically ruled whether the police should have used force properly or not in this case is a matter of social or political concern within the First Amendment. And therefore, now the lower court is going to have to balance his free speech, as potentially severe as that sounds, with the city's right to potentially discourage this type of speech because it disrupts the efficient performance of their services. So warning to employees, the lower court is going to address this. Marquardt is not out of the woods, but he did get this to a court to determine whether this is protected under the First Amendment of the Constitution, as provocative as that is. So I want to be clear. If you discover employees of the city are saying provocative things, off duty in particular, please direct those matters immediately to the city attorney's office. That begs for some human resources and legal determination about the scope of that. Can I explain why? Because the very next slide, remember that Sixth Circuit, Marquardt? 2 months later, they came out in favor of the employer. In this case, employee who's a city dispatcher for Nashville, Tennessee, posted a number of racially derogatory social media posts on the night that President Trump won the election in 2016. Employees saw this, complained, and the employee said, hey, all of these social media posts about race were just being sarcastic. They weren't anything other than good humor. And interestingly enough, while certainly the employee's position about the presidential election was a matter of public concern under the First Amendment, the employee's racially derogatory statements brought discredit to the dispatch office and the police department, and that didn't pass muster under the First Amendment. So can public employees potentially, if their words impact their city, can they potentially lose their job or suffer adverse consequence as a result of saying things that clearly overstep the city's guidelines, in this case, racially offensive social media posts? Does any of that make sense? You have to know these two cases. They're not our jurisdiction, but I think our jurisdiction would view them the same way. And it's important that you understand that employees who overstep bounds, even using their First Amendment protections, may not necessarily be protected if they jeopardize the city's ability to function effectively. Hope that makes sense. I always do these classes with the permission of the city's HR and the city's legal team. This is one of those areas where you have to go to them if employees are saying offensive things. And I want to make sure that everybody gets their First Amendment protections, but everybody understands there are limitations to those First Amendment free speech protections. That gets me to the slides I didn't get to, and that's the cases of interest. I'm not going to read you every case of interest that I found. I just wanted to leave them in the slide deck if you thought they would be interesting. And the only one that I put up first was this issue of the employee who refused to be vaccinated for religious reasons. Is offering that employee a job that takes them out of harm's way is potentially reasonable, even if the employee didn't find that to be as same or as desirable a job. So we can accommodate people who pose vaccine objections, even to a job that they might not find that desirable. Please be aware of that. Any questions for me? I told you we were going to come up on that 2 hours, a lot of information. Wanted you to see what I thought was important. I wanted you to have the slides so you could potentially see some of these cases that have come up in the last year, but I don't want to bore you by reading cases. It's not what we do. I really wanted to highlight those new responsibilities to safeguard equal pay, to ensure that people have an understanding, and especially you, about this new sick leave benefit, and to understand that new protection for employees who blow the whistle during a public health emergency on any safety concern they may have. That's where I'll leave you with this time. Please feel free to, I'm going to send the recording to the city. You're more than welcome to watch it again. I was speaking so quickly, I probably went over a few things too fast, but maybe if you listen again, you'll be able to decipher some of the things I was saying there. Great to talk to everybody. I wish we were in person. This is the kind of year where so much was going on that it begs for your questions. But I think with chat, we got a lot more questions answered than in previous years. So thank you for always engaging in these classes. I wish you all a happy holiday. Hey, I also have a book out there on the streets that people should think about if you really want to learn a lot about the law. So it's important. Oh, I saw that. Government restriction on support animals on the aircraft will that affect the workplaces? Interestingly enough, we already have restrictions on workplaces about it, but it's going to be an issue in terms of our emotional support animals, which is this chapter. Are emotional support animals going to be a reasonable accommodation in the workplace? So I love that you brought that up. Thank you. Everybody, have a great rest of your year. Let's hope 2021 is substantially better than 2020. And great to see you at least online. I'm going to end the recording now as well.